C-SPAN friends, welcome to the National Constitution Center's second day of Supreme Court recap. I am Jeffrey Rosen, the president of the National Constitution Center, and it is such a thrill to welcome all of you today as part of this historic experiment to hear Supreme Court arguments live for the first time in American history, and then to convene advocates and scholars who have filed briefs on both sides of the case to help us learn together and understand what we've just heard. The National Constitution Center is a private nonprofit with an inspiring mission from Congress to disseminate information about the US Constitution on a nonpartisan basis in order to increase awareness and understanding of the Constitution among the American people. And that's just what we're trying to do as we learn together during these important arguments. Joining us to learn and to help understand the arguments we've just heard are two of America's leading advocates and scholars of the Constitution, both of whom have filed briefs. They're called amicus briefs or friend of the court briefs on different sides of the case. Walter Weber filed a brief in support of the petitioners, who are known as USAID, and of course the case is USAID versus Alliance for Open Society International. He is senior counsel for the American Center for Law and Justice in Washington, D.C., which is the organization on whose behalf he filed a brief. He's written many briefs in landmark cases at the Supreme Court. And before joining ACLJ, he served as a staff attorney with the Catholic League for Religious and Civil Rights. And Ilya Shapiro has filed a brief on behalf of the Cato Institute in support of the respondents, who are the Alliance for Open Society International. He is the director of the Levy Center for Constitutional Studies at the Cato Institute and the publisher of the Cato Supreme Court Review. Walter, Ilya, thank you so much for joining.
Glad to be here.
On this, part of this grand experiment, as you said.
It is part of a grand experiment. I just keep thinking of those words of Justice Holmes in defining the Constitution. He said, "It is an experiment as all of life is an experiment." And I have to say, based on the arguments yesterday and today, I think the experiment is going very well. So let's be part of that grand tradition. And Walter, perhaps you could begin. We just heard the lawyer for the government arguing on behalf of the government. That was Christopher Michael, assistant to the US Solicitor General. And he said that the case comes down to two basic propositions. First, that foreign recipients of aid lack constitutional rights. They cannot bring a constitutional claim. And then he said that neither the respondents also can't bring a constitutional claim because any effects on their message is a product of their own choices, not of government coercion. Can you please unpack and summarize the core of the government's argument in this case?
Sure, and please let me know if I'm going too long. This is
just like Chief Justice Roberts, he's been very good at this. So keep it crisp at the beginning, and then we'll have a lot of time for a lot of questions.
Listeners need to understand this is a follow-on case. There was a case already decided by the Supreme Court addressing a lot of the main issues in this case. And what the court, okay, back up a second. This has to do with a foreign grant program. That is to say, United States money being shipped overseas in order to address some issue. In this case, it's fighting the spread of HIV and AIDS. And because Congress was of the view that prostitution and sex trafficking are an important vector in spreading these diseases, what Congress did was added a clause to its statutory grant authority saying that you're not eligible to receive these grants unless you have a policy explicitly opposing sex trafficking and prostitution. Grantees, domestic grantees, said, we object to having that policy. We'd like to be in charge of our own, what policies we have and what we don't have. And we think it violates our First Amendment rights to say we're not eligible for this money unless we have the government's preferred policy. The Supreme Court, by a divided 6-2 vote, Justice Kagan recused, said that that's right. The First Amendment is violated if you are insisting that they adopt this policy as a condition of eligibility to receive the foreign grant. The case went back down to the lower courts, and the grantees who had won said, well, now, wait a second. It's not just us. We have foreign affiliates who are receiving the money as sub-grantees or as contractors with us. And we think they should not be subject to the policy either, because what sense does it make for us to say, we're not going to be pushed around by the government on adopting these policies, but the grantees are going to have to. It's the same logo, it's same brand, same name. We think that violates the First Amendment as well. The lower courts all agreed, said that does violate the, as to affiliates who are sharing the same name, logo, and brand. It violates the First Amendment for them to be subject to this policy. The government then said, hold on a second. There's a long-standing line of cases that this court has recognized saying that foreign entities operating abroad do not have constitutional rights. The domestic grantees have one. They can operate abroad. But if they're going to affiliate with, as either sub-grantees or contractors, foreign entities, they have to recognize those entities can't get under the umbrella of the First Amendment. It does not cover them. And therefore, the same ruling should not apply to the foreign entities. That's the gist of the government's position.
Many thanks for that, for reminding us that there is this important 2013 case, USAID, which said that the domestic entities can't be forced to take the pledge, but that the core of the government's case is that their foreign affiliates, CARE India, for example, lacks those rights and shouldn't be able to claim them. Ilya, in this argument, the lawyer for the petitioners, Mr. Boker, David Boker, the Alliance for Open Society, said that there are two violations of the First Amendment rights of the US respondents. First, he said the speech compulsion is attributed to them. When Karen Kenya takes the pledge that it won't support prostitution, its actions are attributed to CARE US. And the second is the speech restriction that prohibits the US entity from even contradicting the pledge on its own time and dime. He used that phrase, quoting from Chief Justice Roberts' original 2013 opinion in the USAID case, making it impossible for CARE US to disavow the message without doublespeak. And using those phrases, time and dime and doublespeak, and quoting from Chief Justice Roberts' opinion, Mr. Boker was appealing to the chief, basically saying this opinion is covered by the decision you wrote in 2013, which, by the way, was 6-2. Justice Kagan was recused from that case, as she is from this one. So Ilya, tell us more about how David Boker was saying that the 2013 decision clearly covers this case and that the First Amendment rights of the US entities are being violated by the restriction on their foreign affiliates.
Right. From a layman's perspective, the first point is basically it. If you have some foreign affiliate who takes a particular position, people don't, the general public observing this, they don't say, oh, well, that's CARE India, that's not CARE USA or CARE Global or what have you. It's colloquially or commonly attributed throughout the network, and that's where the second part comes in. There's this restriction on disavowing. You really can't do that in various ways. I think that the nut of this whole argument and of this whole case comes down to something that Justice Sotomayor said. Well, once she found her unmute button for the second consecutive day, she had an issue with that. Justices, they're just like us. And she said, quote, in the First Amendment context, we're much less concerned with the corporate formalities. And you can look at cases as different as Hobby Lobby about the First Amendment rights of a closely held public corporation, or the Hurley parade case. We don't look to see whether it's a partnership or an S corporation or a nonprofit or whatever. However you structure your legalities, that's beside the point of whether there are First Amendment rights. And at the end of the day, this is much more of a corporate structure case than it is a First Amendment one, because the question is, all right, in 2013, the court did rule 6-2. And by the way, all of those justices are still on the court, except Justice Gorsuch replaced Justice Scalia and Justice Kavanaugh replaced Justice Kennedy. So I suppose those would be the swing votes, as if you will. But the point is, does that 2013 ruling apply to those foreign entities? And I think this is simply a question of, in the First Amendment context, it does, because the corporate niceties don't matter so much for purposes of protecting free speech rights. As Justice Ginsburg said, It's not just whether foreign entities or individuals or persons have First Amendment rights under the U.S. Constitution. Typically they don't, but about the U.S. government's obligation. Congress shall make no law not to infringe on those speech rights or to compel them in some way.
Many thanks for that. Let's talk more about the question about whether the distinction is formal. The very first question that Chief Justice Roberts asked was, it's one thing that's not clear is the precise relationship between the foreign and domestic entities. Is it reasonable to insist on formal corporate ties in this context? Mr. Michaels said our position is that a formal distinction between the entities is all that's needed to attach separate legal rights. And then many justices noted about corporate formalities. As you said, Ilya, Justice Sotomayor said, the Hobby Lobby case, remember friends, that was the famous case that said that the religiously scrupulous corporation couldn't be required to offer the contraceptive coverage, suggested that they were less concerned with corporate formalities than with perceptions. People might think that the Hobby Lobby Corporation was endorsing the contraceptive pledge. And then at the very end of the argument, Justice Gorsuch said, well, do you have to, you said the primary harm was the mistaken attribution of the foreign affiliate speech to the domestic entity. That sounds like an alter ego argument, but you'd resist any attempt to pierce the corporate veil. Why should we attribute the speech of the foreign affiliate to the domestic entity? And the answer of the respondents was, we don't ask the government to pierce the corporate veil. There's the danger of speech being attributed even when the corporate formalities are imposed. So Walter Weber, that's a long way of saying, what is your response to this crucial distinction in the argument? Should we take a formalistic or a pragmatic view of whether the speech of the foreign entities will be attributed to the domestic entities? And what is your argument about why we should view this formalistically rather than pragmatically?
Sure. Well, a couple of things. First point is the Supreme Court has not been consistent on this. If you look at the common sense of it, which I think Ilya was wisely pointing to, you have, say, an entity like Planned Parenthood, and then you have Planned Parenthood Action, or whatever they call their PAC. You'll have the ACLU, and then you'll have the ACLU 501c4, or maybe a PAC associated with it. And so you, on the one hand, you have, say, a group like Planned Parenthood saying we are a nonpartisan, nonprofit group, but on the other hand, you'll have an entity that has Planned Parenthood Action as its name, battling for particular candidates who support their position. All right. Now that's their right to do that, but the Supreme Court has said it's also legitimate for Congress to say you aren't entitled to the nonprofit status if you are a campaign entity. So you have same logo, same name, same general worldview, and yet formalistic distinction allows you to do things that you'd never be able to allow to do if you had a different formal status. Is a guy in the street going to say that looks the same to me? Yeah, probably. Does it matter nonetheless? Yeah. So we have at best an inconsistency on whether or not the corporate form is decisive. And the Supreme Court has said in the context of lobbying, in the context of whether you're a tax deductible entity, that it does matter. So then why can't that same distinction apply when you say, well, we have a domestic entity that is restricted, but the foreign that is not restricted, but we have a foreign entity that is restricted, and that just is part of the territory. Now, the second point I wanted to make is that part of the problem that the government faces in this case is that it's fighting with one hand tied behind its back, and that is the court, as the attorney for the Solicitor General said, we fully accept the court's prior decision. Our amicus brief takes the position that the prior decision was a mistake. And that's because the prior decision turned on the notion that there's compelled speech here. Our view is the voluntary acceptance of a limited discretionary grant program is not compelled speech. No one's required to apply for foreign, I mean, for that matter, 99% of the people in the United States aren't even going to be thinking about applying for a foreign grant to combat AIDS and HIV overseas. It's something that you voluntarily undertake, and it's typical with voluntary grant programs by the government to accept the strings that go with it. That said, it's an awesome power of the government, right? If it controls the budget, it can pull strings, it can push people around. So it's very important to draw a line between those kinds of programs that are discretionary, limited focus, targeted programs like fighting smoking, fighting drug abuse, fighting HIV/AIDS, versus a general program like access to parks, access to libraries, can you drive in the HOV lane, where it will be completely impermissible for them to say you can only do so if you accept the government's position on smoking, sex trafficking, etc. And so we say the court should reconsider that original decision, because like you've buttoned one button wrong on your jacket, you're going to get the subsequent buttons wrong.
Thanks so much for that. And thank you for signaling a very important point in your brief. You argue that the original 2013 USAID decision was incorrect, and the court should overturn it and allow foreign aid to be conditioned on ensuring that the organizations that receive it are basically on board with the general purpose of the program. Ilya, as we know, the court is reluctant to overturn its prior decisions, especially a 6-2 decision. And your Cato brief argues that this case was already decided by that 2013 decision. You say that the distinction between foreign and domestic affiliates is unsupported by the record, which demonstrates that the speech by close foreign affiliates is indistinguishable from respondent speech. And you say that the technical distinction between the two was rejected in that previous decision as evident hypocrisy. And Justice Breyer seemed to pick up on that notion too in several of his questions. He said, following up on Justice Ginsburg's question, if the organizations say we're against prostitution, but the foreign organizations are disavowing it and the domestic organizations are saying that they don't support that pledge, Justice Breyer said, some of the prostitutes will say they're hypocrites. How does that change one iota, said Justice Breyer, if instead of sending their own worker over there, they give the money to a foreign worker in India and that foreign worker says the exact same thing to the prostitutes? How does that interfere one whit less that they will be seen domestically and otherwise as hypocrites interfering with their mission? If we accepted that argument before, why should we accept it now? Ilya, tell us why Justice Breyer seemed to be suggesting that this case was clearly covered by that 2013 decision and why you believe that it is.
Well, it's for free speech purposes, it's a distinction without a difference. This is not about piercing the corporate veil in terms of tort or contractual liability issues or issuing stock or some other reasons for which we have the corporate form and we have affiliates and corporate parents and things like that. This was a colloquy with Justice Gorsuch towards the end of the argument. For free speech purposes, it's very different. And indeed, it would be, I don't know, it would be hypocritical, it would be disingenuous to continue with a particular policy while one body still refuses to adopt it or another one does. At the end of the day, this is a question of imputation. And if, in many of these cases, the corporate entity exists not even for some sort of legalistic immunity or protections with respect to corporate law or tort liability, but because in many countries around the world, including the United States, you have to have a locally incorporated affiliate to be able to do business, whether as a nonprofit or a for-profit. And so in many cases, this came out right off the top with the Chief Justice's first discussion with the government lawyer that they had no choice to incorporate local entities. So it's not even a matter of wanting to have some sort of legal separation. It's that they had to be able to operate in that area. So again, just in the speech context, it works differently, or in terms of many fundamental rights rather than when we're talking about contractual relationships, business liability, or anything else from the civil litigation world.
Thank you for that. Walter, before we dig into your argument that the original USAID decision should be overturned, let me ask you about Justice Kavanaugh's questions. He said in both of his
Jeff,
rounds,
can I add one thing?
Sure.
in terms of overturning the previous precedent, I think there's less than a zero chance of that, because that was a no offense to Walter, it was a strongly written brief, of course, but that was a 6-2. You take away the justices that were no longer on the court, it becomes a 5-1. So even if you add Gorsuch and Kavanaugh to the dissent, there's still 5 votes for that previous position. So the only question is whether, as we put it strongly, that the previous decision controls this one, or whether they even have to explain a little bit further to get to where they would need to go.
Well, since you pressed that point, let me pose that to Walter. Do you believe there's any realistic chance that 6-2 decision will be overturned, given the composition of the court? If not, why did you decide to call on the court to overturn it rather than arguing, as the government did, that the previous decision could be reconciled with a decision to treat the foreign entities differently? And then maybe this is the chance to say very clearly what it was about the previous decision that you think was incorrect and should be overturned, as Justice Scalia laid it out in his powerful dissent in that decision.
Sure. Well, all right. Going first to what's the odds question. One of the reasons why we filed this is because we think it's really important for the Supreme Court to get the law right. And even if it gets it wrong, if no one points that out, then it becomes entrenched and it's harder to fix down the road. There are 2 new justices on the court. One of them replaced someone who was in the majority the last time. One replaces someone who was in dissent. I'd like to see both of them at least note that the arguments that we make have some force. And while that question may not be presented in this case because the government concedes it, that they would at least recognize, even if they don't write it in, at least recognize in their minds that there's a potential vulnerability in the Death Star, so to speak, in the previous decision that may become an issue down the road. And that leads into where we want to go with the merits on this. The previous case turned on the idea that making a funding condition, a string for receiving funds, part of the grant program, is the equivalent of compelling speech. Now, the First Amendment is a very powerful weapon. You cannot just not compel someone to adopt a policy. You also can't forbid them from having a policy. You can't even prefer them because they do or don't have a policy. So let's take an example, which I hope everyone would agree on. Child sex abuse, all right? There used to be a group called NAMBLA, which was purported to be in favor of pederasty. If the government and it doesn't have to be the federal government, okay? Ilya and I, one of the things we strongly agree about on this is the federal government's size and ability to coerce people with funding is a huge problem. So let's take it to a state. Suppose a state wants to have an anti-child abuse grant program. NAMBLA applies. It says, we'll only use the funds to fight child abuse. We won't use any of the funds to promote child abuse, but we're going to retain our policy in saying that with consent on both sides, an informed adult and an informed minor can engage in sexual relations, right? The government, it seems to me, is entitled at a minimum to say, we're going to give preference to groups that don't have an express policy in favor of child abuse, child sexual abuse. Under the rationale of the first AID versus AOC program, it seems to me that cannot be done. Because what they're saying is that if you have a First Amendment right to have or not have a policy, and the government can't require it, they certainly also can't prefer it. They can't say we're going to disqualify or even give lower ranking to NAMBLA in its application for grants because of its policy. Where does that leave the government in its ability to preserve mission integrity? I mean, you can't have someone who represents a tobacco company talking to teens about why they shouldn't smoke. They're going to laugh. And you can't have somebody from NAMBLA effectively saying, we think child sexual abuse is bad, should be stamped out, because they're going to laugh. It's not going to be effective. Which is why I think that there's a fundamental category problem with the first decision. Yes, it's true that you don't want the government to be able to use its whopping pile of cash as a carrot or a stick to say, go along with all our policies and you'll get the money. That's a problem. So you have to come up with some coherent line between, on the one hand, saying no one can use the library, no one can use the public park unless they sign on the dotted line on the government's preferred positions on abortion, same-sex marriage, prostitution, you name it. And again, it can go both ways depending on who the administration is. So this should be a bipartisan, nonpartisan issue. Some line between saying no one can have these privileges that everyone else has unless they toe the government's line, which is totally wrong and unconstitutional, versus saying if we're going to have a targeted program to fight some evil that we've identified, whether it's smoking or child sexual abuse or whatever, we want to prefer people who are with the program rather than those who are either opposed to it or are indifferent and just doing it for the money.
Thanks so much for that. And thanks for this great opportunity to examine the merits of the original case. C-SPAN friends, it is so meaningful to be able to go back to first principles. So that was the Agency for International Development versus Alliance for Open Society case from 2013. And the line that Chief Justice Roberts adopted in that 6-2 decision was the following. He said, the distinction that has emerged from this court's cases is between conditions that define the limits of the government spending program, those that specify the actions that Congress wants to subsidize, and conditions that seek to leverage funding to regulate speech outside the contours of the federal program itself. And then he acknowledged that the distinction between conditions that define a federal program and those that reach outside it is not always self-evident, but the court is confident that the policy requirement here falls on the unconstitutional side. Ilya, can you help us understand that distinction that the Chief Justice was embracing? Is it true that Congress could not say that a child support agency in the US not support child abuse, or would that be within the conditions that define the program itself? And would it only be people who are distributing aid unrelated to child welfare who would not be able to be restricted from supporting NAMBLA? Help us understand the core of that distinction.
Right. So this goes towards the doctrine of unconstitutional conditions, not specifically the First Amendment. That is, the government can't tie your ability to exercise one constitutional right to your waiver or restriction, voluntary, quote unquote, voluntary restriction, or giving up the right to exercise a different right. And the line that you just read from Chief Justice Roberts, I think that's apt. It's basically, in other contexts, called germaneness, how germane is the condition you're putting on to the program at issue. In the context of a policy that would be adopted, it's kind of like, well, do you require all program applicants for funding to fight HIV and AIDS to say that they are against the spread of HIV and AIDS, or are you requiring them to say that they are for the flat tax, right? The latter, clearly unrelated, clearly not germane. Well, on what side of that line is this position about prostitution? And to Walter's point, if this is a program to advance government policy to fight prostitution or to not decriminalize it or to criminalize it further around the world, then yes, it would be totally germane, totally within the four squares of the funding program to say, yes, you have to adopt that policy to get the funds to advance that position. In the case of NAMBLA, well, if the government's position is that sex between minors and adults is de facto or de jure by law child sex abuse, then sorry, you're not going to get access to anti-child abuse funds. So again, there has to be, how germane or how close to the actual mission of the program that you're designing is the applicant. And that's really what the debate in 2013 boiled down to. Yes, it's obviously a speech restriction or compulsion, implicates the First Amendment because we're asking you to adopt a particular policy. But again, there wouldn't have been a problem if that policy for the Fight HIV/AIDS program was you have to agree that HIV and AIDS are bad or we want to prevent its spread. But this unrelated or sufficiently unrelated policy of where you stand on prostitution, the court found correctly, I think, for reasons described elsewhere in John Roberts' opinion, lies outside of that line.
Thanks for that. Walter, are you questioning the germaneness distinction itself? In other words, Chief Justice Roberts' distinction between conditions that define a federal program and those that reach outside of it? Or are you just disagreeing about on which side of that line this speech about prostitution falls? In other words, do you have to call for the 2013 decision to be overturned, or just say that they got it wrong on the facts?
Okay, first of all, let me say is, as I feared, Ilya and I are agreeing on an awful lot of things, but we're not necessarily agreeing with what the Supreme Court said. The Supreme Court passage that you read talked about the scope of the program versus the activities outside the program, or the larger entity that's applying for the grant. And I think the germaneness issue is a totally different question. And I agree with Ilya that should be one of the decisive factors. If you say you can't get HIV funds unless you also agree having Puerto Rico as a state, right? Has nothing to do with the program. Obviously, the unconstitutional attempt by the government to leverage your ability to get money into political compliance, and that's a problem. But the Supreme Court didn't say that. They said that the difference was between the scope of the program versus your outside larger existence and functioning. And I don't think that stands up with the germaneness question, because suppose you had an anti-terrorism program, right? And you want to say, we're not going to allow Hamas to participate. Or you have an anti-smoking program, we're not going to allow the tobacco company to participate. Now, tobacco company can say because of what they do, rather than what they say. But with Hamas, you have an organization whose position is antagonistic to the goal of the program. They can promise all day long that within the scope of the program, they're only going to use money to fight terrorism. Maybe it'll be terrorists, that they don't like. But their viewpoint, their organizational perspective is what disqualifies them for the grant. But that's outside the scope of the program. Same thing with the groups that wants to say repeal all laws against drug use, right? Like it or not, if you've got a program that's going to fight drug abuse, and you have an entity which formally thinks that those restrictions should be limited, the government, I think, can rightly say it's germane to our program to disqualify you, or certainly at a minimum to prefer someone else, because your viewpoint and policy are inconsistent with the goals that we want to see accomplished. And therefore, the nature of the entity that you are is going to be undermining our efforts to have an effective program. So Ilya and I can disagree on whether or not a policy about sex trafficking and prostitution is germane to fighting HIV/AIDS. I don't think that the Supreme Court decided that question. On the contrary, they seem to accept Congress finding that this is germane because prostitutes and sex traffickers are one of the main vehicles for the transmission of the contagion. In fact, apparently Congress found that 40% of prostitutes in Cambodia were HIV positive. Well, you don't want the very activity going on that's going to further the problem you're trying to fight. Now, again, Ilya and I can disagree on whether or not that's germane or not, but I don't think the Supreme Court decision turned on germaneness. If they fixed it to make it turn on germaneness, I'd be a lot happier camper.
Great. Well, let's return to the oral argument and the implications of a decision on either side. Justice Kavanaugh asked both parties what would the practical effects be, and in particular, he said, I'm interested in the implications of this decision if the government were to lose. Would any other statutes be called into question by such a decision? And the government's lawyer said, I do think so. It would call into question a number of statutory and regulations of foreign speech that couldn't be applied domestically, like congressional bans on campaign contributions by foreign entities, or opposing terrorism or apartheid or women's rights. Congress also often imposes content-based viewpoint restrictions on foreign aid, and domestic entities able to unite with their foreign bodies to challenge this would be quite disruptive. Ilya, in your brief, you have the opposite concern. You say that an argument against the domestic entities could allow the government to force recipients to espouse any number of messages that come into the government's favor. Non-government organizations receiving government aids could be required to give a disclaimer before administering vaccines, stating that vaccines do more harm than good. You say that organizations that receive funds to export U.S. agricultural products could be forced to declare their products have been genetically altered, or scientific groups that receive funds to research climate change could be forced to say that they don't believe in climate change. So who has it right? Is it more dangerous, as Justice Kavanaugh's question suggests, to allow to prevent the government from imposing these conditions, which could call the campaign finance restrictions into question? Or are you more concerned that allowing the restrictions would allow the government to impose its message on lots of foreign groups?
Well, campaign finance law is a separate area of First Amendment doctrine, and we have certain kinds of regulations and restrictions about foreign entities there that we don't that doesn't transfer to other areas of speech regulation or First Amendment doctrine. But the passages in my brief that you quoted, and I have right here, you took the wind out of my sails a little bit by preempting me on that, but that's exactly right. And it comes down to how the government draws up its program here. So Justice Kavanaugh at the very end asking David Bowker, the lawyer for the respondents, the Society for the Open Society Institute, what implication could this have on foreign policy? Let's say the government wanted to promote peace in the Middle East. Could it condition that on organizations that recognize Israel? And the answer to that is yes, because part of the U.S. government's commitment to peace in the Middle East is a recognition of Israel. Now, if the U.S. no longer recognized Israel or said that the existence of the state of Israel was a problem for Middle East peace, then that would transform the argument. But there are certain realities. Similarly with Hamas, if you're giving out anti-terrorism funds and the U.S. government certifies that Hamas is on the list of recognized terrorist entities, well, that's kind of like the NAMBLA example again in the domestic sphere. So I think foreign policy concerns are overblown, but again, it's how you design the program. If it's a general program of funds for, I don't know, good government or good policies without defining them further, then that would be a lot harder to restrict. But if the government says, we're going to try to prevent the, again, it's and I think Walter and I are in agreement on this, in that you have to, the way that Congress draws up its program, it can't willy-nilly say you then have to adopt policies that aren't necessary to carrying out whatever it is that you're doing. And so the consequences of a ruling in the government's favor would be to chill speech, to prevent domestic actors that are related to those foreign actors through, again, these corporate niceties from engaging in the kind of operations that they want to be engaged in, or choosing which of their rights they prefer to exercise.
Thanks for that. And it's interesting that you use that word chilling. Justice Gorsuch said, I think the argument goes beyond the forced association, which was at issue in the St. Patrick's Day parade case, the Hurley case, to the chilling effect of speech. Justice Gorsuch said the First Amendment isn't just concerned about protecting speech, but is concerned about the chilling effect of speech. And the answer there of the government's lawyer was, I don't see any chilling effect. Domestic entities are free to take the money and use it themselves or work through foreign affiliates. Here, respondents are asking for a right to optimal message management. That was a kind of memorable phrase. Walter, what did you think of that response? And also, what did you think of the response to Justice Kavanaugh's question about whether, if the government wanted to fund NGOs, but only those that recognized Israel as a legitimate state, Mr. Boker's response was, that's a harder case. I don't hear that as requiring affirmation of a belief. It's recognizing a fact that the US has established a relationship with Israel.
All right, taking the first point, there's a legal doctrine that focuses on the causation of a particular problem. In other words, if you're challenging a law that you think restricts your ability to do something, but there's some third-party actor that's part of the problem, you won't necessarily be able to get the relief you're entitled, that you would like, because there's someone else involved. Suppose you want to be able to run ads in a newspaper supporting a particular issue, but there's no newspaper in your town, okay? The government can't require a newspaper operator to spring up in order to satisfy your First Amendment desire to exercise your First Amendment rights. So if you have a foreign country that says you can only operate in this country if you have an entity that's incorporated in our country, which I understand is being one of the respondents' complaints in this case. They're saying, well, sure, great, it's easy for you to say we can do whatever we want, but the fact of the matter is country X won't let us operate there unless we have a foreign entity as a subgrantee. Well, then your problem is not with just the government's program, it's with the foreign government telling you you have to have a foreign entity, and that's not the United States' fault. So that's why I think the question is arising. Are you really asking us to solve a problem that's not the United States is making? The optimum functioning principle is not something recognized in the First Amendment law, because you really don't have the right to change the environment to make it more conducive to what you want. I want a red light put in here so that people will stop and see my sign when I'm standing by the side of the street, right? You don't have the right to have that happen. So if it's the problem is the foreign government saying, we're not going to allow you to operate in this country unless you have a nation that's an entity that's incorporated here, then that's the problem, not the government's policy. Now, the second thing, what you're asking, what about specific policies? Okay, let me give you, sorry not to accept your hypothetical, give you what I think would be even more hot button, abortion, right? Everybody who has feelings on abortion has strong feelings on them often. And it's something that cuts both ways. And depending on who the administration is, you're going to either have a desire to ease access to reproductive rights overseas, or the desire to restrict our implementation of things that coerce people to violate human rights of the unborn, okay? If the government has a program designed to further the government's policy, shouldn't it be allowed to say, we're not going to fund people who have a mission statement that is inconsistent with our goals? If we are the Obama administration, we're not going to fund Human Life International as a grantee to increase women's access to reproductive health care. If we're a Trump administration, we're not going to fund International Planned Parenthood Federation to increase respect for human life in the womb. It seems to me that that's common sense. Obviously, it has First Amendment implications, and that's why it's so important, as both Ilya and I have been talking about, you have to put really strict limits on what the government can do to justify that kind of restriction. You have to have germaneness. You have to have it be a limited scope, targeted policy. You have to have something that's discretionary, right? Because if everyone's required to go along with it, then they're required to sacrifice their First Amendment rights. So you have to have all these high walls drawn around this government power because it is so powerful. But on the other hand, if you completely eliminate the power, then you're essentially saying the government cannot have any kind of mission focus, because it has to accept whoever comes along as long as they are objectively, mechanically qualified for the grant.
Thank you for all that. Ilya, are there any limits to your claim that the First Amendment rights of the domestic entities should carry over abroad? Justice Ginsburg asked, you say that the Eighth Amendment doesn't apply abroad, but does that mean the government operating abroad can torture people? So are there any circumstances under which a domestic aid organization could not resist a requirement imposed on its foreign affiliate?
Well, the Eighth Amendment example, I think, is apt because their international law would come into play in treaties and things like that. We have laws, statutory laws against torture and related things, but the Eighth Amendment doesn't apply. I don't think that person getting tortured can then go into U.S. court and say that I've, my Eighth Amendment rights have been violated. I think it's a different kind of case. So the specifics of the law matter, and here the specifics of the law is corporate law. And so if we accept that domestic entities have that kind of right and not to be compelled or restricted in the ways that this program implicates, then the question is, does that legal formality of having a foreign affiliate affect that protection? And that gets us back to what we were saying at the very beginning. So you do have to look at the theory of the matter of the particular right being invoked or the legal claim being made. It's not so much that foreigners have these constitutional rights, First Amendment or otherwise. It's how does recognizing or not recognizing those kinds of freedoms or preventing the government from imposing those restrictions, what effect does that have of the rights of entities and persons, corporate or natural, in the United States?
Thank you for that. And C-SPAN friends, National Constitution Center friends, just a quick review. The Supreme Court has held that certain constitutional rights apply abroad and others do not. It held in the terrorism cases that even a foreign detainee held outside of US jurisdiction has a right of habeas corpus, that is a right to challenge an allegedly unconstitutional conviction. Whereas the Supreme Court also held that the Fourth Amendment right against unreasonable searches and seizures does not apply abroad. That was a case called Verdugo or Quides, because Chief Justice Rehnquist said that the right of the people to be secure in their persons, houses, papers, and effects, people refers to citizens of the United States and doesn't apply abroad. And Ilya is arguing, as the respondents here did as well, that what matters is the corporate form, that is the rights of the domestic organization, and also the nature of the restriction being imposed. Walter, I wonder what you make of both of those claims. You say in your brief that the unconstitutional conditions doctrine would not permit the government to condition unrelated grants, such as grants to assist taxpayers with IRS filings, on an express anti-suicide policy. So you do seem to think that there are certain kinds of conditions that would be so unrelated to the purpose of the grant that they wouldn't be allowed. Tell us more about how you would define that limitation, and also the degree to which you think the nature of the corporate form limits the degree to which restrictions can apply abroad.
Sure. Well, the basic idea is that the government should not be allowed to leverage your constitutional rights out of existence through the use of money. That's different from saying that the government can have a program that it's going to have criteria for eligibility, make sure you're qualified, basically, to undertake it. So anytime you've got something that's available to the general public, like access to a park, using the public library, eligibility for food stamps, welfare programs, the government cannot say you're only going to be able to get these benefits or enjoy these programs if you sign off on our policies A, B, and C. The only possible exception to that would be if the policy was really strictly germane to what you're doing. I agree that I'm going to return my library books on time, right? You know, that's as a condition for you using the library. Beyond that, there's the problem, great potential of government abuse. And that's why, as I was saying before, we have to have these really strict high walls surrounding that power to limit it. Of course, that's not the only way to limit it. The other way is to say, well, is it really true that the government has all these powers to intervene in ways that it is currently doing, or have we strayed from the original vision of the federal government as one of limited powers and instead replace it with this octopus whose tentacles are now reaching into all aspects of our life, right? I mean, why is the federal government regulating what's on your food products and that kind of things? Because of commerce, right? But commerce in a global society ends up being everywhere, and then the government ends up having unlimited powers. That's a separate problem, but it gives rise to what we're seeing here, because whenever the government has a role, it will necessarily at some point be politicized. And if it's politicized, then you're going to have winners and losers. And that, I think, is maybe one of the most important lessons we can take away from this case, is that do we really want the government to be in a position where our only defense is to argue over whether this restriction is germane or not? Shouldn't we really be trimming back, lopping off some of those tentacles and saying, you know, we have states, we have local governments, shouldn't they really be the ones who are in charge of a lot of this, rather than having the federal behemoth be the one that's going to be calling the shots? I hope that's helpful. I mean, you also asked about the corporate entities. That's one of the ways that the government is saying we're going to have a limit on our restrictions. We are able to boss around, if you will, foreign entities because they're separately incorporated. But if they're domestic, then okay, we're going to defer to the Supreme Court's decision.
Thank you for all that. Ilya, well, of course, you and your colleagues at Cato are determined to lop off the tentacles of the federal behemoth, and you're often opposed to government regulation. But you believe that this case is important because our ruling in favor of the government would give it further discretion to impose its tentacles as a condition of aid. So tell us why our viewers should care about this case. We've already talked about some of the horribles that you raise in your brief, but if by chance the court were to rule for the government, what are you concerned might happen?
In that case, the government could arbitrarily pick winners and losers and attach conditions, give a Hobson's choice, if you will, for in this case, nonprofits, in other cases, contractors, to decide whether they want federal funding to pursue their mission, or whether they would rather maintain their mission, their conscience, not be hypocrites in certain ways. This, I think, conversely to what Walter just said, it would rein in federal power, congressional power to require Congress to legislate with more specificity. That is, this is not an argument about government power in the sense of can Congress or can the federal government have a program to prevent the spread of HIV and AIDS abroad, or for whatever other purpose. But must it legislate with specificity, really? And so there's nothing to prevent the Obama administration from saying we want to have a foreign program to increase access to abortion. If Congress legislates in that way, they can have that program and deny funding to the Human Life Mission and other pro-life missions, anti-abortion groups. Conversely, if the Trump administration wants to have a program to promote the sanctity of life in the womb, again, using Walter's words, then absolutely they can prevent then Planned Parenthood from getting access to that kind of fund. So it just, again, depends on how you draw up your program. And at that point, you can add extraneous conditions to it.
And Walter, your response?
I think Ilya's got it exactly right. We agree.
But you don't agree about the disposition of the case. So why should our viewers care about this case, and why are you concerned that if the court rules against the government, that these bad things could result?
I think, well, okay, let me phrase it this way. Ilya and I agree on the principles. It's the particular application is where the dispute comes up. My problem is that I think that the Supreme Court didn't adopt the germaneness test that Ilya and I think makes sense to apply in this case. Instead, adopted a scope of the program test. And a scope of the program test would allow Human Life International to say, we're going to be accepting these grants, except that when we accept these grants, we're only going to use them to increase access to reproductive health care. And International Planned Parenthood could accept the grants and say, while we're in favor of abortion, in this grant program, we're only going to be working to increase an appreciation for sanctity of life in the womb. And I don't think that makes sense in terms of government coherence. And if you're going to have a rule that says the government can take a position on these issues, which I think is undisputed, then it doesn't make a lot of sense to say it can have that position, but then it can't effectively carry it out unless it does it itself, as only government agents acting. It can't contract with other people to do it, and consistent with that, impose eligibility criteria that are limited in a germane way to the program at issue. So in this case, my main concern is that we have an entrenchment and possibly an expansion of a ruling that is off in its footing back in 2013.
Thanks for that. In our Q&A box, Bonnie Zedek asks, how much do you feel is lost because the justices are unable to immediately interject their questions or comments and are limited to being called on by the Chief Justice? The less senior justices who go last can follow up on their predecessor's line of thinking, but the senior justices who go first have no limited opportunity to do that. I was struck by the fact that the justices are following up on each other's questions. Justice Gorsuch on Justice Sotomayor and so forth. Ilya, how do you think it's working? And has that affected your sense of which way the argument is going? I'm not asking for predictions in these convenings, but we do want to get a sense from the arguments about what the justices were most interested in. Do you feel that going in order of seniority changes the way they're signaling whose side they're leaning toward?
Well, this is the second day, the second argument that we've had this way. I think we need a little bit more evidence. I'm still processing kind of the effectiveness or how this changes argument. It's certainly, on the one hand, it's more orderly in the sense that it's a series of dialogues rather than kind of a cacophony of different people jumping in at different times, which has a certain type of effectiveness. On the other hand, there are still time limits, and so the Chief Justice does jump in to cut off both the counsel and sometimes his colleagues when they've already had enough time to ask questions. So it's not an unlimited series of dialogues. I don't know how this would affect things long term. There's probably not 9 different lines of inquiry for every case that the court takes up. So there's going to be a lot of overlap and following up, and that's probably good. On the other hand, it does make it a little harder to predict because all the justices are asking questions of both sides, which they don't always do in the live argument. For this case in particular, I think there was more skepticism of the government's position. It'll probably be a fairly narrow ruling, I'd have to say, just saying that the distinction in the corporate form doesn't make a difference here, and we just further apply our 2013 ruling. I don't know what the eventual vote count would be, whether it's again 6-2 or 7-1, but anyway, that does seem what it's like. But it's definitely a different and interesting dynamic, and you can see that Justice Thomas, who rarely asks questions, I think he asks an average of 3 questions a decade, I think, if you look over his career, has both yesterday and today been asking his full allotment of time and of questions. And he is the second justice. He's the most senior associate justice. So he goes right after John Roberts and asks very important, serious questions that his colleagues go after. So he clearly prefers this structure. We've changed in our history of the Supreme Court, both in terms of how they write opinions, how they do argument, a whole host of things about the process has changed. So I don't know, even if we don't have cameras in the courtroom or live audio streaming when we go back to the court, maybe it would be nice to have a little more orderliness so that all of the different lines of inquiry can be quite clear rather than either the justices or the counsel scoring debating points.
Many thanks for that. Well, it's time for closing arguments in this great discussion. We're going to try to be as on time as the Supreme Court. So Walter, maybe some quick thoughts about the format and whether this sequence of asking questions in order of seniority is working or not, and then your final thoughts about why you believe that the government should win this case.
Sure. 2 points on the format of the argument. One is I think it's probably a lot more merciful for the advocates, because it used to be that you would have incoming fire from all directions and sometimes simultaneously, whereas now it's much more orderly. You take the justices in order and you're getting questions in a discrete fashion. I have to think that makes it easier to stay balanced, focused, and to proceed through what you want to get across. Second point about the order is that I think this will definitely diminish the influence of the younger justices, because sometimes a question at oral argument can shape the way a discussion goes. If someone raises a point or extracts a concession that changes the perspective of the other justices, that can then change what they do with the case. Whereas in this case, you're only going to get that at the beginning of the argument from the senior justices. By the time it gets to the newest justices, their ability to do that is going to be much more limited, just because they haven't been able to speak. So they kind of like have to sit there chomping at the bit, waiting until it gets to their turn. As far as the argument itself, the previous case I think was much more important than this one. I think Ilya is right. This is probably going to turn on corporate niceties and imputation versus separate identity, and I think the court could go either way on that. I think the larger points that the audience should keep in mind from this is, what do we do with the problem of a government that's large, and it controls funds and then has the ability to dictate what we have to do in order to go along with the program, versus, on the other hand, maintaining some genuine concern for the government's ability to be effective, as opposed to just being subject to whoever comes along and says, well, I'm going to do your program, and you don't get to look at what I stand for, because the First Amendment prevents you from doing that.
Thanks so much for that. Ilya, last words to you. Why is this case important, and why do you think the government should lose this case?
Well, it's important because it's about the conditions that the government can put on our exercise of speech rights, or of any right. Really, do you have to choose between your rights? And what are the standards courts apply in evaluating claims that that's what the government is doing? Because this comes up in a lot of contexts, First Amendment and otherwise. And the government should lose and will lose, because this court, the Roberts Court, is most solicitous of First Amendment rights. So I think they will continue that trend here, as well as recognizing that corporate niceties in constitutional as opposed to civil litigation cases are less important.
Thank you so much for that. Dear C-SPAN friends, National Constitution Center friends, thank you for joining us for this great educational experiment. Tomorrow's cases are the Little Sisters of the Poor, which is an important case involving religious freedom, and also the Bar versus American Association of Political Consultants case involving the Telephone Communication Protection Act and all those robocalls, and whether restrictions on them violates the First Amendment. To prepare for these cases, this is your homework. Please read the briefs in the cases. As you've seen from these fascinating oral arguments, you can't really have a sense of what's going on unless you've taken the time to read the briefs, read the main cases that are being discussed, and you can find all of them on the Supreme Court website at supremecourt.gov. Just with a little bit of homework, you will be as prepared as our two great advocates. Ilya wants to point, but he can't because our format is firm as the Supreme Court's is. And
I just wanted to say that I filed in both of tomorrow's cases as well.
Okay, a plug for your own briefs you can definitely make. And congrats for your productivity. So read Ilya's briefs, but also make sure to read the briefs on the other side. Ilya, okay, I'll give you a shout out. You did win an award for the funniest brief last year, which was well deserved. So you'll find amusement and instruction if you take the time to educate yourself about the Constitution. And that is what we're all doing, learning here together in this great experience of hearing Supreme Court arguments live for the first time in US history. Thanks so much, friends, and look forward to seeing you tomorrow. And thank you so much, Ilya Shapiro and Walter Weber. Thank you.
Thank you.
See you tomorrow. Bye.